Hello and welcome to the 2TG Employment Monthly. This is webinar 3 and we're going to be looking at the key issues in relation to March 2022. Given it's quite topical at the moment, this webinar is going to deal with the end of COVID-19, or is it? And what in fact does the future hold? I will do my best to not make too many references to the fact that a number of the changes are taking place on Friday the 1st of April, or which is commonly known as April Fool's Day, and it might be quite relevant to the question of what the future holds. Living with COVID-19 pandemic does continue to dominate the agenda, not just across all elements of life, but also specifically in relation to employment law. On Monday, the 21st of February 2022, the government announced that most of the remaining rules in place would be ending, and the final date of cut-off would be the 1st of April. This included the legal requirement to self-isolate being removed as of the 24th of February 2022. And the adults who tested positive would continue to be advised, but only advised, to stay at home and avoid contact with other individuals for at least 4 or 5 days and continue to do so until 2 negative tests were received on consecutive days. Employees, however, are not under a legal duty in accordance with the Living with COVID guidance to notify their employers that they in fact have COVID-19. This does not mean, however, due to the Living with COVID guidance, that the common law duty that employers have to employees to take reasonable steps to prevent harm to employees disappears. It simply means that the various different regulatory requirements are no longer in place, or as we will address, potentially that's not the case going forwards. The Statutory Sick Pay SSP rebate scheme is quite fundamental to the Living with COVID guidance. And during the course of this month, there have been numerous amendments to the SSP scheme with regards to COVID-19. From 17th of March 2022, SSP rebate scheme closed, and employment claims cannot be made in relation to COVID-19 for absences or self-isolation that occur after the 17th of March, and employers have until the 24th of March to submit any new claims for absence periods up to and including the 17th of March, or to amend any claims that they've already submitted. So it's a very clear placeholder in the guidance that 17th of March really is the absolute cut-off date. And from the 24th of March 2022, all COVID-19 provisions in respect of statutory sick pay will in fact end. Now, this leads to some potential questions and queries going forwards that employers should be mindful of. When dealing with statutory sick pay, the guidance creates a distinction between those that are vaccinated and unvaccinated. And it's very important that looking at the policies that are in place within the employer's guidance, that actually there is not a policy that creates any form of potential discrimination between any protected groups. Now, a tribunal has recently concluded that fear of COVID-19 was in fact not a protected characteristic, but that's not to say that the fear of potential vaccinations or a fear of needles may not fall into that protected characteristic, because it's not been a matter yet that's been tested and considered by the tribunal. If the employee is not able to show in these circumstances direct discrimination, there, however, may still be the potential for the employee to argue that there has been, in fact, indirect discrimination. Turning further into the guidance, we have the final cut-off deadline in relation to the end of the regulations which address COVID-19 within the Living with COVID guidance, and that is, of course, the 1st of April, Friday the 1st of April. Now, the general health requirements for employees regarding COVID-19 are set out expressly in relation to what employers should be considering with regards to COVID-19. From the 1st of April, the general public will have to pay to take a COVID-19 test, even if they are demonstrating symptoms. So therefore, if an employer does in fact require employees to test regularly, the test will have to be provided by the employer. Now, employers need to be mindful that the cost of lateral flows are varying very much by the retailer that are providing those lateral flow tests. They cost from £2.50 per test to a pack of 12 for £47.50, and therefore the costs are going to likely to add up if in fact an employer is requiring an employee to regularly undertake lateral flow tests. Also from the 1st of April, the health and safety requirements for employers to explicitly consider COVID-19 in their risk assessments is going to be removed. Now, that doesn't mean that employers shouldn't continue to identify poorly ventilated areas and take steps to, in fact, improve airflow. Now, just because the health and safety requirements to consider COVID-19 are being removed, it doesn't mean that employers should not consider the needs of employees who are in fact at a greater risk for COVID-19, including those whose immune system means that they are a higher risk of serious illness from COVID-19. Now, taking a step back from the fact that as of the 21st of February, we have a gap from then on to 1st of April. And as we can see, and as we're all aware at the moment, infection rates are still high and are increasing by the day. We seem to be seeing a huge influx over the past 2 weeks. And of course, that couldn't be considered or thought about in February because it wasn't going to be predicted or expected. Now, bearing in mind, Friday the 1st of April is when we are taking away the general health requirements which are specifically relevant to COVID-19, we have, as of the 28th of March, 214,679 new cases of COVID in the UK, and this is a sharp contrast to the 21st of February when there were 38,524. And therefore, we should be keeping in mind that when undertaking risk assessments, we need to look at the general data in relation to COVID-19 at the same time. Can employers enforce no working from home? Of course, we've all become very acquainted and used to the terminology of WFH, or working from home. And very peculiarly, the Living with COVID guidance actually doesn't expressly address working from home. It needs to be remembered that it is possible for employees to refuse to return to an office. And we've always had that set into a statutory implement through section 44 and 100 of the Employment Act 1996, where employees are protected from being subjected to a detriment or being dismissed for exercising their right to refuse to attend their place of work. However, with regards to section 44 and section 100, there is only the ability to address those rights to refuse under specific circumstances, and they are set out here at number 1 to 4. Number 1, that the individual, the employee, generally believes that there are circumstances of serious and imminent danger. Number 2, that the belief is reasonably held. Of course, that's a very key word, reasonably. Number 3, the danger is such they cannot be reasonably, again, we see the repeat of the word, expected to avoid it. And number 4, accordingly, they refuse to attend their workplace or a relevant part of their workplace. Now, we've had 2 decisions which have come out of the Employment Tribunal, which are looking at the refusal to attend workplace in the context specifically of COVID-19. The first I'm going to address is Mr. Rogers and Leeds Laser Cutting Limited. Now, the facts are very similar to probably facts that we heard at the time of March 2020 when the first lockdown occurred, which is the concern and thoughts of individuals about whether they needed to be in the office or whether they could, in fact, work from home. But of course, it's not just whether you feel like you want to work from home, as we will address. There are much more issues that need to be considered. Now, Mr. Rogers was a laser operator, and he was therefore unable to work from home and had to attend his workplace. At the start of national lockdown, Mr. Rogers' employer wrote to his employees confirming the measures it was putting in place and its expectations for employees who could not work from home. Mr. Rogers, in response, stated that he would not come back to work until the lockdown had eased, and he was subsequently dismissed on the 24th of April 2020. Now, the Employment Tribunal held that Mr. Rogers was not automatically unfairly dismissed. In fact, Employment Judge Anderson found as follows at paragraph 48. The government guidance at the time centred around social distancing and hand washing. The workplace is large with a handful of people working within it. At the time, on the claimant's own evidence, it was generally not hard to socially distance. In addition, he accepted there had been reminders around hand washing, and he gave some specific examples of this. Having considered all the circumstances, including the claimant's knowledge and the facilities and advice available to him at the time, and bearing in mind his decision to drive his friend to the hospital in circumstances described, I do not find that the claimant believed there were circumstances of serious and imminent danger within the workplace, but that he considered there were circumstances of serious and imminent danger all around. And therefore we can see a very clear distinction being made by Employment Judge Anderson in relation to the workplace and in relation to circumstances in general. He goes on to say at paragraph 51, I have to consider the circumstances as they were at the time of these events and in light of what was known to the parties, and particularly the claimant at the time. We have learned much more about the virus since March 2020, but my focus is on that point in time. He then went on at paragraph 62 to address that the claimant referred to the Secretary of State's declaration of the 10th of February 2020 under Regulation 3, subsection 1 of the Health Protection Coronavirus Regulations 2020, that COVID-19 poses a serious and imminent threat to public health. However, I consider the fact that the virus has been described in those terms does not of itself satisfy this part of the statutory test. If it did, it seems to me any employee or worker could simply down tools on the basis that the virus is circulating in society. Now, of course, it goes to my point I made a moment ago. We all remember there was the very much the concern at the time of individuals about whether they could work from home or whether they needed to be in the workplace. But as is addressed by Employment Judge Anderson, we need to remember that it's specifically at the point at which the individual raises the fact that they are refusing to attend the workplace, and then it needs to be put into a specific timed context, not just general. And it's interesting that Employment Judge Anderson did make a general reference to the fact that, of course, a blanket refusal would not have allowed for the world to carry on in England and Wales at that time. We then have a second case, which again is to address the refusal to attend the workplace. Now, this came after the case of Mr. Rogers. Now, in this case, Mr. Quelch, in contrast to Mr. Rogers, worked in an office-based role, but he had in fact initially worked from home, and he was only required to return to the office from July 2020. Now, thinking about Employment Judge Anderson's point in Rogers, which is about looking at the guidance at the time. The government guidance at the time in relation to Quelch was that you could facilitate working from home as a first option. Now, Mr. Quelch had requested to work from home, however, his request was refused. He was placed on unpaid leave and his access to IT systems was entirely revoked. And he was then dismissed after disciplinary procedures occurred. Now, in this case, the Employment Tribunal, in contrast entirely to Rogers, held that Mr. Quelch had in fact met the requirements of the Employment Rights Act 1996, and he was therefore unfairly dismissed for gross misconduct. Now, addressing Rogers, the Employment Tribunal found that they were able to clearly set out that though the Rogers decision was not binding, it did in fact warrant careful consideration. And there are numerous references through the judgment to Rogers in order to demonstrate the separation between the two matters. And it was felt that the employment judge in Rogers did not go so far as to conclude that conditions pertaining to COVID-19 could never potentially amount to circumstances of serious and imminent danger. The Roger case involved work which could not be performed from home. The claim failed because the judge found that the claimant did not, in fact, believe that there were circumstances of serious and imminent danger in the workplace. As we saw in Rogers, there was the distinction between the workplace and in relation to the world as a whole. Addressing Rogers further, the tribunal felt that the claimant both had and communicated specific concerns about the health and safety risks posed by his return to the workplace. Most significantly, he was concerned that the respondent was not in fact complying with the central plank of the government guidance at that time, that employees should work from home where possible. And although it was possible for him to work from home perfectly successfully. And we need to think about what, of course, bearing in mind those two decisions, and also as we've seen the recent increase in cases of COVID-19, what in fact does the future hold? Now, there does seem to be, as of the 29th of March 2022, an apparent U-turn by ministers. And our employers are going to have to be mindful in the coming weeks and months of a potential rollercoaster of changes. Of course, that will not be an April Fool's of the 1st of April, because new guidance is actually due to be issued today on the 1st of April 2022, which is that if an individual has a cough or cold, they are now urged to stay home and avoid contact with other people. And the key issue now is that we have the Living with COVID guidance for the 1st of April, which doesn't require anything higher than you should assess the risks and consider yourself. Now we're seeing a potential change where it's going to be urging people to stay at home. And if the cases begin to rise, it's expected that there will be a need potentially for a further U-turn in relation to statutory sick pay, which of course, as we've seen, will not have the same conditions and criterion as has existed during the global pandemic. We also need to bear in mind for the future about the potential employment bill and whether actually it's necessary, given this global pandemic, that we should have some form of codification for potential future global pandemics, whether that be COVID-20, COVID-21. And we actually should be thinking about whether some of the regulations and some of the requirements that we have had in guidance and we have codified over the course of the past 2 years, we should be using as templates in case we do face another future global pandemic. For anyone who's watching this and has COVID, I do hope that you get better soon. And if you have family and friends who have COVID, I hope that you will get better soon. And let's hope that the potential for an increase, as we're seeing at the moment, of cases will cease, and we can really hope that living with COVID is going to be the future, and we're not going to be having to look at potential guidance which is going to need to require for more rigorous regulation. Thank you very much.